All right. I believe we are live on all three um, social media accounts. We have YouTube, we have X, and we have Facebook. This is my reaction to the oral arguments in Hamm versus Smith, which is a Supreme Court case that was argued just now. Um, Functionally, this is a death penalty case to determine whether an inmate named Joseph Clifton Smith is eligible for the death penalty. Legally, the question is, how are the courts supposed to combine the different IQ scores that often death penalty prisoners have? It's very common over the course of before they commit a crime, and into the trial process and appeals for people who are eligible for the death penalty to have multiple IQ scores. This is a scientific question that there's no clear consensus on. Are you supposed to average the scores? Are you supposed to take the median or the middle score? In other words, are you supposed to find where their error ranges overlap? The state of Alabama, on its side, is saying that when you ask this question, you need to first look at whether it is reasonable to believe that a person does have an IQ low enough that they are probably intellectually disabled. And then after that, you can then give the prisoner the chance to prove that, yes, I do have an intellectual disability. So for Alabama, first the IQ scores take precedent. And once those seem to be low enough, then the prisoner can be given the chance to show this. And they have to show it with a standard called preponderance of evidence, which means more likely than not. Okay. The other side, Smith's lawyers, argue that by themselves, IQ scores cannot foreclose off that possibility that the person can prove that they have an intellectual disability. The argument on that side is that you always need to consider all of the evidence, IQ scores, and especially adaptive functioning, which is how someone functions in everyday life in their before they go into prison. And so what we see here is a couple of questions. Some of them are legal, some are scientific. The Alabama side is more interested in the scientific question. They say, look, there's a lot of different ways you can combine IQ scores. And when we do this, we need to give the states the right to do so. But the IQ scores are the most objective evidence we've got here. So that's Alabama's argument. And they say only when there's the realistic possibility should we allow non-IQ evidence to come into play. The prisoner's side of the argument is much more permissive. And one of the lawyers at one point said the argument basically comes down to possibility versus preponderance. In other words, on the prisoner's side, it's, hey, if there's any possibility this person is intellectually disabled, that we need to be able to present all of the possible evidence and make the strongest argument possible. Alabama's side, the state side, is saying, yes, there are conditions in which IQ can open the door, but those other pieces of evidence are almost always less reliable than IQ. They are almost always less consistent. They're usually gathered less systematically. And we shouldn't be able to just say, okay, yes, there's the possibility of a low IQ. Now let's talk about all the other evidence. So a lot of legal battling back and forth, a lot of scientific battling. Here's what I see as going on. Um, there was a lot of talk about standard error of measurement, or SEM. One of the judges kept just calling it a SEM. I've never heard of a psychometrician just calling it a SEM, but you can think of that as being like a margin of error around um, IQ score. And the question very much is, what does combining these IQ scores do to the standard of error measurement? Because past Supreme Court cases have said you have to take the standard of error of measurement into consideration. Everyone on every side agrees that even though you get an IQ score, they're not perfect, and the person's true functioning may be a little bit above or a little bit below what the IQ says. And so that's the scientific question of what does this do? If I had to read the tea leaves, the Supreme Court justices are not very interested in mandating one way or two ways to combine different IQ scores. They don't seem to be interested in that at all. The interest is more on finding legal rules for whether this door opens up and who gets to decide those legal rules. Alabama wants the courts to defer to the states to say, hey, look, once you meet this minimum threshold, once there is any uncertainty about whether this person has a disability or not, then the states should get to set their own rules, leave it up to the states. The other side, the prisoner's lawyers, argue that, hey, we need to allow all of the evidence to come through completely. My perspective is that there's a more convincing argument that this adaptive functioning evidence, how well does a person function in day-to-day life, which is an important piece of diagnosing an intellectual disability. I thought that the Alabama lawyer's argument was more convincing, that evidence is less reliable, it's less systematic. Sometimes it just happens to be what school records survive. That's more available for cherry picking, either for the defense or the prosecution, whereas the IQ scores just sort of let the chips fall where they may. And so Alabama wants the IQ scores to be weighed more heavily, and wants states to have the right to weigh those more heavily. And so scientifically, I think a lot of this not only turns on how do we combine IQ scores in this case, but also how much does the non-IQ information matter? I don't think either side wants to ignore it completely, but the prisoner side is much more open to that non-IQ evidence. I find it less convincing. There's no dominant daily functioning score or daily functioning test that everyone seems to rally behind, the way there's a small number IQ tests that everyone rallies behind for prisoner purposes. I also was much more convinced of the argument that, hey, it's easy to cherry pick this. It's easier to slant this non-IQ evidence one way or the other. So I don't think the judges want to set a method of combining it, but I think they are much more interested in giving guidance of saying, here is when the door is open to this other evidence. And I think some of them might be interested in letting the states decide that, but it's hard to read the tea leaves. The most skeptical judge of the Alabama position by far was Justice Sotomayor. She didn't see any problems with how previous Supreme Court cases were being implemented. She didn't have a major problem with allowing all this non-IQ evidence to come in and allowing the expert witnesses to just duke it out in court and let judges decide. On the other side, I'm not 100% sure which one it was, but I want to say it might have been Alito, Justice Alito, who was much more skeptical about that non-IQ evidence. Beyond that, it's really hard to read the tea leaves. I'm not sure how they'll go. Let me look at some more of my notes. A lot of the debate was about, from the legal perspective, are we trying to find someone's true IQ? I use air quotes for that, quote unquote, because it's debatable about whether that's a technical term. Or are we looking to see whether someone is diagnosable with a disability? Again, I don't know how the justices are going to fall on this. But there was a lot of wrangling about how much does IQ define one of these or another, and how do we combine these in different cases. I do think that the strongest argument for the prisoner's side was when the lawyer said, "Look, it's important to be able to move on from IQ sometimes. That yes, it's an important consideration to see whether there is a possibility, but after that possibility is there, we need to talk about someone's daily functioning." They also argued very strongly against the idea that you can't artificially limit the evidence available. The prisoner side was very interested in holistic argument, and they said, yes, you should be able to consider every reputable IQ score, but we should also consider data and testimony from people who knew the prisoner. We should look at school records. We should look at whether they could open up a bank account and hold down a job, etc. That side of the prisoner's lawyer, really said that by keeping the focus on IQ, we're artificially limiting the evidence available. What else did I see in my notes? As far as one of the arguments in one of the amicus briefs, that's a brief of a third party who's interested in the outcome of this case, was arguing that applying the rules from previous Supreme Court cases has been very difficult. There needs to be better guidance, and the current guidelines are not adequate for that. Alito is very sympathetic to that position. That was a position that the state of Kentucky made. And so I think if I had to guess, I would say that we're going to see a ruling in the summer about clarifying rules about whether this is the state's prerogative as long as you meet a minimum constitutional standard, or whether it's just open to allow in all sorts of other IQ data. So I don't think they're going to rule on scientific issues. I don't think they're going to rule on how to combine scores. I don't think they're going to give recommendations to the courts or the states for that. I think it's very much going to be on with IQ. Is that enough to close the door? How does it open the door to other evidence? And how much should we weigh other evidence? So that's where I see this going. I thought both sides, both lawyers, there were two lawyers arguing on on the Alabama side, the Alabama lawyer, and then a representative from the Solicitor General of the United States speaking on behalf of the federal government. And then on the other side, we have the prisoner's lawyer. I think that all three of them raised very good points scientifically and legally. It's not an easy thing, and the justices are going to have a lot to chew on. But I think they're going to eschew scientific ruling, focus on their legal ruling, and try to clarify rules and guidelines so that we don't get this type of case popping up at the Supreme Court every 5 to 10 years as we've had lately. So that's what I think's going on. This is my really quick reaction. Like I said, I think it hinges on whether we're going to talk about the possibility versus the probability that someone has a disability. In other words, if there's even the slightest possibility, are we going to open up the floodgates to this other evidence, or are we going to require this to be more likely than not that the person has a disability? And then what are we looking for? Are we looking for a diagnosis, or are we looking for a true IQ level or true intellectual functioning? So it was interesting. There's a lot to chew on. I encourage you to listen to the arguments yourself. They're recorded at supremecourt.gov, and very soon I bet that a whole bunch of other websites will also share them. But that's my viewpoint. Please like and subscribe and follow Riot IQ to learn more about IQ. And we'll probably revisit this issue at the very least in the summer when a ruling comes out, but also possibly before then. So take care.